Hello again, everyone. Welcome to Washington Gun Law TV. I am Washington Gun Law President William Kirk. Thanks for joining us. Where the hell am I today? I am at 3 Aces right out here in the Spokane Valley. We're going to link them up down below so you guys could check out all the good folks and the cool things they got going on here at 3 Aces. Going to do a follow-up video now, America. We got to talk about this Rahimi case. Now, I told you it's 108 pages. I've had a chance to geek out on the whole thing, and I got to tell you, although I'm not going to get too worked up about the ruling itself, I am going to get really worked up about some of the language that the Supreme Court has chosen to use. I think there's a lot of problematic language. I think this is an opinion that's going to come back and haunt us in many ways, and I also think it has a huge implication on what may happen with a lot of other big issues that we are anxiously awaiting for. So today, from 3 Aces here in Spokane, let's spend a few minutes and let's talk about the long-lasting implications of the Rahimi opinion. Okay, hey, before we get going too far down the road, we are going down. You know, we tell you here all the time at Washington Gun Law, we're not going to tell you how to think. We're just going to give you all the stuff to think about. Well, does the news treat you the same way? And that's why I've been using Ground News, because in today's world of media bias and censorship, Ground News gives you the freedom to learn for yourself, attach your own weight to the facts, and come to your own conclusion. Wow, what a concept, huh? Here's how it works. Take today's story, for example. You start searching it out, and now, 1, you can see who the news source is and what is their political leaning. 2, you can learn who actually owns those individual news sources. 3, you can see the headline manipulation, so now you understand how the story is being distorted. And most importantly, 4, the biased distribution of each story. But then there's a lot more cool features. Like Discover Plus, which is unlocked only with a Vantage plan. But here you can customize your own news feed to cover the topics that interest you the most, like, Second Amendment news. Then Ground News will populate your news feed based upon these settings. Here's the best news. Right now, you can get 40% off a Vantage plan by visiting ground.news/Washington. Listen, it's time that you break free from all the media bias and manipulation. It's time that you start being able to make up your own mind. It's time for the news to start treating you like an adult. For more information, visit my good friends at ground.news/Washington. Okay, America, this is what we're talking about. We're talking about United States v. Rahimi. Now, without getting too spun up, and I know some people are all freaking out thinking that the Supreme Court got this wrong. And I'm not going to necessarily come out and say the Supreme Court has got it wrong, because if you recall, we were saying at Washington Gun Law all along that there was a historical tradition dating way back to be prior to the Declaration of Independence that allowed us to disarm people that we deemed to be dangerous. Now, I get the criteria that we were using in the 1600s and the 1700s are repugnant by today's standards, but nonetheless, we as a society have accepted that. I had actually predicted that Rahimi was going to lose 7-2. It turns out Rahimi actually lost 8-1, with the sole dissenting vote being that of Justice Thomas. Now, I've had a chance to go through the opinion, and this is what I want us to kind of view here. The first angle is, what effect might this have on cases such as Range versus Attorney General of the United States and United States versus Daniels? In addition to that, what effect might this have on all of the Illinois assault weapon ban cases? Because as we know, we got 4 of them sitting right there on the front door of the United States Supreme Court. The second way I want to view this case, and this is what really has me concerned more than anything, is that we have already seen sloppy language that gets inserted into an opinion that can then be used by those that are supporting gun control legislation to say, hey, this is what the case law clearly stands. We literally have opinions right now that are saying, well, Bruin stands for the proposition that we get to ban all firearms from individuals and things like that. So again, we look carefully for problematic language, and unfortunately, there is a lot of problematic language in this opinion. Now, ultimately, the ruling of the court, if we're going to boil it down into its most simplest form, is as follows. When a restraining order contains a finding that an individual poses a credible threat to the physical safety of an intimate partner, that individual may, consistent with the Second Amendment, be banned from possessing firearms while the order is in effect. And listen, even though I am deeply concerned about some of the problematic language, Chief Justice John Roberts did point out in a very wise statement the dangers of disarming the American population. As a leading and early proponent of the emancipation observed, disarm a community and you rob them of a means of defending life. Take away their weapons of defense and you take away the inalienable right of defending liberty. But with this in mind, the Supreme Court was still comfortable allowing Mr. Rahimi to be disarmed. Now, as far as problematic language goes, we have oftentimes said that there really is no such thing anymore as innovative gun control. Because if it's innovative, it means it's new. And unless gun control measures have some type of historical foundation to them, they simply cannot survive a constitutional challenge. So we thought. But this paragraph here in Rahimi is deeply concerning. Nevertheless, some courts have misunderstood the methodology of our recent Second Amendment cases. These precedents were not meant to suggest the law trapped in amber. As we have explained in Heller, for example, the reach of the Second Amendment is not limited only to those arms that were in existence at the founding. Rather, it extends prima facie to all instruments that constitute bearable arms, even those that were not yet in existence. By that same logic, the Second Amendment permits more than just those regulations identical to ones that could be found in 1791. Holding otherwise would be as mistaken as applying the protections of the right only to muskets and sabers. That there is an incredibly loaded paragraph, okay? Because what it does with the inclusion of that language is it's going to allow courts that are in favor of civilian disarmament to say, well, they have always said that gun control laws are not trapped in amber, and this allows for innovative and new gun control measures. The middle language there, which again firmly restates the Heller opinion, that is why I believe you're going to see the Harrell case, the Barnett case, the Beavis case, the Calkins case, all four cases out of the state of Illinois, which we were hoping to get a final resolution on an assault weapon ban. Yeah, it is that language right there that I believe is going to end up getting all of them GVR'd, granted, vacated, and remanded back down to the Seventh Circuit. Now, in relation to an issue which has been debated predominantly in the Ninth Circuit, which is, do we need historians to come in and actually tell the court what the history of the Second Amendment is and things like that? The Chief Justice here has made it very clear that that really is not necessary. After all, it's the role of the court and the lawyers to do that, as the Chief Justice put it. Discerning any development of the law in this way is commonplace for any lawyer or judge. Now, the big reason that Justice Thomas dissented in this is he believed that the laws that were used to justify the existence of this particular federal statute prohibiting individuals under indictment or under protection orders from being armed was that there was not a sufficient historical analog. And really, this in many ways does become one of the big subjective natures of the test. How close to an historical analog are we actually operating with? Unfortunately, some of the other problematic language that's included in this opinion includes this. Even when a law regulates arms bearing for a permissible reason, though, it may not be compatible with the right if it does so to an extent beyond what was done at the founding. And when a challenge regulation does not precisely match its historical precursors, it may still be analogous enough to pass constitutional muster. The law must comport with the principle underlying the Second Amendment, but it need not be a dead ringer or a historical twin. And by taking these surety laws and going armed laws and saying, hey, that is a sufficient historical tradition, it really puts back into play some of the other ridiculous historical analogs that we've seen proffered by courts supporting civilian disarmament, such as the Bowie knife, gunpowder storage. And again, the problematic language that we find in the majority's opinion is, taken together, the surety and going armed laws confirm what common sense suggests. When an individual poses a clear threat of physical violence to another, the threatening individual may be disarmed. Section 922G8 is by no means identical to these founding era regimes, but it does not need to be. Its prohibition on the possession of firearms by those found by a court to present a threat to others fits neatly within the tradition the surety and going armed laws represent. Okay, and then finally, I mentioned that, hey, what about the Daniels case, which deals with cannabis users? What about the Range case, which deals with nonviolent felons, and the fact that they are both awaiting acceptance or denial from the United States Supreme Court? Well, here's why I think those cases are getting GVR'd. It's due to this problematic language in the Rahimi opinion. Finally, in holding that Section 922G8 is constitutional as applied to Rahimi, we reject the government's contention that Rahimi may be disarmed simply because he is not responsible. Responsible is a vague term. It is unclear what such a rule would entail, nor does such a line derive from our case law. In Heller and Bruin, we use the term responsible to describe the class of ordinary citizens who undoubtedly enjoy the Second Amendment right. But those decisions did not define the term and said nothing about the status of citizens who were not responsible. The question was simply not presented. And for that reason, I firmly believe that you're going to see both the Range case and the Daniels case GVR'd by the United States Supreme Court probably as early as next week. The bottom line is this, is I know many people are having problems with the holding of the court itself. We have not really broken that down. This video is not about that. My problem is with the language that has been used here, some of the sloppy language that has been used, which I can guarantee, America, you're going to see these words beaten over our head over and over and over by many of the Ninth Circuit, Seventh Circuits, and other courts out there that are hell-bent on disarming you, the lawful and responsible gun-owning American. The case, once again, is United States v. Rahimi. We're going to go ahead and link it up down below so that you guys can geek out on it for yourself. Maybe you got questions about this or anything else related to what's left of your Second Amendment rights. If you do, you should know how to get a hold of Watching the Gun Law by now. If you don't, that's okay. That information's down there in the description box. Maybe you got an idea for a video we should be doing here. If you do, go ahead and click on that link right there. Some of the best ideas we ever had actually weren't our ideas. And then finally, and most importantly, let's everyone remember that part of being the lawful and responsible gun owner, like we talk about all the time here, is to know what the law is in every situation, how it applies to you in any instance that you may find yourself. From 3 Aces here in Spokane, Washington, thanks for watching and stay safe.